Good morning or afternoon. This is an information presentation regarding ethical practices. Specifically, the task we're going to discuss today are 4 topics, and we're going to choose one that is most applicable to our current work environment. This slide outlines the 4 topics of information we're going to discuss. It's going to be about client confidentiality, informed consent, clients that turn 18 while in a mental health facility, and parental notification. Let's begin with client confidentiality. Client confidentiality is obviously a pretty big situation when it comes to dealing with confidential information. Things that should happen or not happen is there should be no information revealed to a third party or anyone, even a parent or a spouse, without expressed written consent of that client. HIPAA is the Health Information Portability Act is a prime example of that. The privacy part of that is even if you're literally on your dying deathbed and the client or patient in this case has not signed anything that outlines whether they can share information with you or not, the doctors or nurses and healthcare professionals of all sorts are bound by that client confidentiality. It could be released to law enforcement agencies with proper authority. For example, a court order. If someone is subpoenaed to share information that is critical to a case, if a felony or something's to be committed or has been committed, and that information is to be released, and the individual chooses not to, they could be potentially held in contempt of court. This applies to anyone that has that client confidentiality part of their principles and their code of ethics, like doctors, attorney, priests, and yes, our psychologists as well. Breaching the confidentiality, even though it may be for the greater good and that someone is put in jail, that trust that is broken and that betrayal of the client goes deeper than just something being shared, and it's hard to get back in the future. Also, client confidentiality can be breached if a client is dangerous to themselves or others, if they're in the commission of a crime, or we know that they have tendencies that they may hurt themselves and someone needs treatment options. If the client's a minor and a victim of a crime, we can share information about what's going on with the proper authorities. And like I said earlier, when the client is considering committing a crime, if there's something we can do to prevent that, then client confidentiality is no longer a barrier. Informed consent, it has to do with the nature and the purpose and treatment and the use of the information. A lot of the informed consent is about what are some of the risks and benefits of a particular treatment, or in the case of research. If the people that you're getting information from will relinquish their rights to sharing how the treatment presented itself with them. And one thing about informed consent also is that it allows ample time to discuss any and all the information. Just don't shove something in front of somebody and say, here, sign this, and it should be as simple as possible to understand. And it also should be in an appropriate setting as to how that informed consent's gained. You don't want to do it in times of duress or when someone is stressed or anxious about a situation. These could cause problems with it potentially later in a legal setting. Um, and also, those that are seeking the informed consent needs to ensure that they have the proper training and how to secure that informed consent. Again, it's just a matter of it's not a matter of just throwing it in front of somebody and say, "Here, take this, sign it, give it back to me. You don't need to read anything." It all needs to be done in the proper setting. And of all things, there doesn't need to be a lot of legal jargon, a lot of information that a client may not understand. Turning 18 in a mental facility is a topic of interest to the legal community and mental health care professionals. 18 is that magic age of majority. It's whenever you can, go vote and buy cigarettes and do all kinds of things, but sometimes that may not be in the best interest of a mental health patient at that point in time. Some countries have no age of consent, and it goes on what their mental capacity is versus a chronological age. Canada, for instance, in some circumstances, some provinces have that clause as to they may be 18 or 19 years old, but present as a 14-year-old emotionally and psychologically, and therefore consent is not an issue. If a minor turns 18 in a facility, the 18-year-old can literally get up and walk out if they choose to, because they no longer have to have their parents' consent to any kind of psychiatric treatment, and they can just leave the facility on their own if they choose to. They're no longer considered an adolescent, but a young adult with decision-making authority. And they can also be offered a young adult transition program, but oftentimes that requires lots of paperwork, and sometimes the transition can be lengthy. So it's a tricky situation when this happens. Parental notification, at 18, that right is transferred to that individual. This is usually seen as like a proactive step for a parent to help head off drug or alcohol abuse type things in a college setting, or if there's a health or safety concern that someone from the college or facility may call and let parents know. Assent or dissent is age and maturity dependent. A child, even though if they're age of minority, if they're less than 18, they still need to be aware of what's going on and really assent to the treatment, because you want to work with them and not do something to them. And these parental notifications laws will vary from state to state. One of the things that's most applicable for us in our current work environment is about client confidentiality. And for us, FERPA, the Family Education Rights and Privacy Act of 1974, has a goal of protecting the integrity of a student's academic record and protects the student's privacy. Sometimes parents get very upset that I want to know how my child's doing in school. Well, if the child hasn't said, release my records to my parents, we can't tell them what's going on. We can't even tell them their grades. We use a National Student Clearinghouse database where it talks about what the education status is and what previous universities that a student may have applied to or completed information. We have many databases through the Department of Veterans Affairs and the Department of Defense that we access that gains information to a lot of personal data, and also these are all for us to help them receive their education benefits. The use of Social Security numbers we have those. We use those all the time because we have to have those for National Student Clearinghouse data, and we also need to use them for the VA databases. The personally identifying information, or PII, we have a lot of information that is collected on our candidates and our participants that, if abused, could be very, very harmful and dangerous to our clients and to our participants. We could easily open financial accounts in their name. We have student workers that we have to vet closely to make sure they understand client confidentiality. And also part of that is the health and medical information we collect. Many of our veterans may have a disability, a TBI or a PTSD situation that, if that information were to get out, it could harm them in the workforce, in the workplace. It could easily, be a major HIPAA violation on our part if we were to do that. And all of this information has to be closely watched and cared for. The references I use for this with Abram, Lentz, Rothklein, and Walker, they all discuss several of the topics that we just visited about. That concludes my presentation.